Great. Good afternoon, everybody. My name is Walker White. I'm the Chief Executive Officer of Oliver Technology Corporation, and I would just like to welcome you to the first of a three-part webinar series we're hosting called A New Paradigm, Creditor-Driven, Consumer-Centric Collections. Today, we're going to be talking about the first of that three-part webinar series, which is going to be the creditor's perspective. I think in the recent Hunstein decision has seen yet more evidence that there is a need for a new paradigm. And over the next 6 weeks, this webinar series will be looking at this. We're looking at this through three different lenses: the lens of the creditor, the lens of the regulator, and ultimately the lens of the servicer. I will be moderating today's meeting, but I assure you that I am the least interesting person on today's call. We're very, very fortunate to be joined today by three people who I think could shed a lot of light on where we are in collections and where we're headed. First, we've got from U.S. Bank, Heidi Wisner-Stallo, who is Vice President and Assistant General Counsel there. We also have Stephanie Jackman, a partner at Ballard's Bar. And we're also joined by Thomas Michael Jr., who is the founder of Oliver Technology Corporation, and obviously my colleague there as well. So again, the format today is going to be a panel discussion. I'm going to ask a few questions, but really the knowledge is going to be coming from our three panelists. Little logistics as we go through the presentation today. In your in the panel that you have when they go to webinar, there's an opportunity to click on the little questions bar. If you click on that, you can pose questions, and we will either try to answer potentially some of them kind of in line in the terms of the discussion, or alternately, we will have a Q&A session at the back end where we can dig into other ones. And any questions we don't get answered, we'll obviously answer and send out to those that attended. So again, thank you for joining. We look forward to having you participate in the entire series as we go through. And with that, we'll go ahead and get started. And again, we don't have any slides to share here. It's going to be just a panel discussion. So I'll go ahead and turn off the slides. And I want to start our discussion today with by talking about really the recent Hunstein decision. It's kind of been all the rage in news in our industry for the past 2 weeks, of course. And really, we at Oliver really see this as yet another catalyst for change. But there's still a lot of change occurring as it relates to the Hunstein decision. So I'd just like to start there. And I think, Stephanie, I'd like to start with you. For anyone who's maybe been living quietly or been on vacation for the past 2 weeks, maybe you give a 60 seconds overview of Hunstein first, and then second, a summary of some of the activities and latest updates from the industry and how people are reacting to it. So, sort of to you, Stephanie.
Definitely, thank you. I'd say the high-level view is that the 11th Circuit overturned a district court decision dismissing a plaintiff's FDCPA claim by holding that the plaintiff's allegations that a debt collector sent information about the debt to an outside letter vendor for purposes of that vendor printing and sending the letter to the consumer stated a claim for a violation of section 1692C subsection B of the FDCPA, i.e. an unauthorized disclosure of the debt. What's been happening since? Walker, a lot. Everybody first just kind of had to react to what was a very surprising decision, given that it's interpreting language. It's been around for almost 5 decades, and we haven't seen this. And letter vendors and other outside service provider vendors are a pretty well-known part of the collection space. And in fact, we're part of what the CFPB analyzed and gathered data about with promulgating Regulation F. Now we are aware that the defendant in that case, well, appellee now, but the collection agency intends to file a petition for rehearing with the panel that rendered that decision, or en banc review from the entire 11th Circuit. The deadline for that filing has been extended to May 25th, and thereafter we expect to see a great number of amicus, as it may be, supporting briefs going to the court, talking about why this decision is not the right way to have applied the FDCPA. And those are due 7 days after the petition is filed by the collection agency for rehearing, so at the latest June 1st. In the meantime, we've had a flood of filings, not just in the 11th Circuit, where this is a binding decision right now, and that would cover states like Alabama, Georgia, Florida. So federal courts in those states are bound by it unless it is overturned. But everywhere else, because the 11th Circuit said that these allegations on their face are enough to state a claim and survive a motion to dismiss. Does that mean that the court has held it as a violation? No, they've held it states a claim.
Oh, good. Thank you. Thank you. Heidi, I'd like to ask you, obviously, as a representative from U.S. Bank and a large creditor is involved in litigation activity and the collection of debt, in these affected states, I'm curious, but two things come to mind here. How did you find out about this as a first-party creditor, and how did you and your organization kind of react to the news of Hunstein?
So I first became aware of it as a colleague forwarded the case to me, or I'd been talking, and said, "Hey, have you heard about that case?" And I said, "No, shoot it my way." And I remember reading it and kind of dismissing it, to be honest, thinking, "Oh, yeah, here's another case. It's going to affect our third-party debt collectors." But as a first party, it's just kind of absurd, and the FDCPA doesn't apply to us. I mean, I think I was quite dismissive, and then a few hours you settle in and your brain starts to look at it. And it was that snowball effect that I think kind of was occurring the same time as it was throughout the industry, as everyone was starting to become aware of it. And so at that point, my business lines that I represent were coming looking for guidance. Do we need to change? Everybody's always right away, what do we need to change? And, you have to kind of calm down that knee-jerk reaction and start thinking it through. So for us in the jurisdictions in the 11th Circuit, probably less worried. We're a little bit more worried about the snowball effect, and not so much just in states that keep coming up, primarily California, I think, for creditors, but just as an industry, how all of this looks and shapes. So in analyzing our internal practices as well as our partnerships with our third-party vendors, we had to look at all of that and kind of do a risk assessment as to, where do we see things are at, as well as where do we feel like we have some strengths in the programs that we've set up. So it was a little bit of a mixture of both, and then trying to exhibit the necessary patience as all of the appeals play out and the new cases come in, and kind of see where it goes, and hopefully better law is made. So from our perspective, in these, it's a lot of heeding the advice of the attorneys that are saying, also just exhibit some patience and, and hold strong in what we believe is doing the right thing for our customers and how we run our business.
Great. Thank you. And Tom, finally to you, kind of on Hunstein, as the founder of Oliver, do you think that Hunstein really represents something, entirely net new? Is this a complete departure from what you've seen or what we've seen, or is it kind of more of the same? Are we, is this a trajectory that we think we're on here?
I mean, picking up where Stephanie left off, the decision itself is certainly somewhat shocking based on the prevalence of this practice and the likelihood that at some point in the prior 50 years of litigating under the FDCPA that we haven't touched this one yet, at least not with this result. So that certainly, the novelty of that is a little bit surprising. What I don't think is surprising is just the direction of this. That almost without exception, in as far back as I can remember, in this industry. The decisions that impact us, they always tend to go in this direction. You know, it's going to be like bringing more and more constraints, of course, on people that work in collections, and providing consumers with more and more protection. And so, for as much as it was a surprising way to interpret perhaps the FDCPA, the direction of it isn't a surprise. And I think, obviously that's part of what I think we want to talk about here is this as just one more piece of evidence on top of, the changes that came out of Dodd-Frank, on top of the entire rulemaking process with the CFPB, and ultimately the content of Reg F, in kind of pushing in this direction. And I think I was talking with a creditor either earlier this week or last week about their reaction to this, and deciding, like, are we going to be in line with the changes that we make that come out of this, if any? Are they going to be in line with a future that's more creditor driven or consumer centric? And I think that's what we're really seeing here with this.
Right.
And that path is a little bit safer one to be on.
Right. Well, and again, this our presentation today here is titled "The New Paradigm," and I think that your question leads me to ask you another question, Tom, which is really about the old paradigm. I mean, here at Oliver, we're talking about the need for the new paradigm, but we first need to understand kind of what is the pattern of the paradigm that we're talking about today. So from your perspective, Tom, or from Oliver's perspective, I should say, can you kind of lay out how Oliver sees the old paradigm, Tom? And then Stephanie, I'm going to come to you about kind of the regulations and regulators and courts after that. So go ahead.
Sure. So I think in describing paradigms, at the highest level, I would say, there's certainly, variations to this and a spectrum of different approaches and strategies. So it's not that there's a one size fits all, environment. However, I would say the paradigm is really based on an older agency model, and I mean agency in the law school version of the concept of agency, where creditors were using third-party vendors to facilitate and manage the process, where the creditor's role was perhaps more oversight and performance based, but at the end of the day, the mechanics for actually accomplishing the work were being facilitated at the vendor level, at that, I should say at the servicer level. So the vendors to the creditors, whether they're networks or agencies or law firms, those are the folks that are really putting rubber to the road on facilitating the process. So I would call the paradigm more of a vendor-driven paradigm or outsourced paradigm. And the implication of that is a couple things, but two of the core parts that really do, in a way, touch on some of the facts that came up in Hunstein were the decentralization of data that comes out of that. So when a creditor sends information and data about their collection files out to their vendors, that data is going to then live in those outsourced locations. And in addition to the data living there, the business processes and the compliance framework that is driving the process is also going to live there as well. So there's fragmentation across both the data and the process. And I would say that's the old paradigm.
Right. Great.
Yep.
And Stephanie, to you, how do you think? I mean, you've been in serving in consulting with organizations for a long time, trying to keep them out of trouble, as you were. But how do you think that the regulators and courts are really influencing the future of collections? I'm just curious on kind of your perspective, looking back over your time of are we right in suggesting that hey, they're kind of channeling us in this direction, or is that just the way the cards have fallen for us?
I think you're exactly right in reading the way that we're being channeled. So starting on the regulatory side, and where I feel like it's moved very rapidly in the last decade with the advent and standing up of the CFPB, which came out swinging, right? I mean, the first few consent orders, they were not against this industry. They were against the creditors working with people in this industry. They related not exclusively, but to kind of vendor oversight, whether it was in marketing, whether it was in how things were being collected, vendor oversight UDAP channels to immediately put a really big name with a really big number out there and start scaring, for lack of a better word, the people that could act like the CFPB, influence relationships in ways to align with practices that we saw the CFPB in particular wanting to happen.
Right.
It was an incredibly effective strategy to rapidly and quickly direct people's attention to, oh, wow, I can be on the hook for this. I better make sure I can't be. And we saw that with just consent order after consent order. We saw that when outside companies, whether third-party agencies and debt buyers, creditors that work with them, and everyone in between, saying, how can I better interact in this relationship? How can I ensure my data transfer is smoother, accurate, get the reporting that you're telling me I need, know more about what's going on, understand if there's complaints. All of that vendor management, compliance management system, CMS, the types of terms we've been throwing around for a decade now, really started to catch fire. And from that, I think you see a direct, I think it's beginning to shift us into this new paradigm with clients like creditors, and looking at Heidi down in the lower screen, but she's certainly not alone. I think, and I don't want to put words in her mouth, but I know that some of my creditor clients would feel like they know much, much more about how the third-party space works than they used to. Also coming with that is much greater confidence in their abilities to manage it, which, for a while might have caused a retraction, less debt sales, less willingness to authorize certain types of approaches, but that's now loosening as they're building their own confidence in their ability to know what the third-party space is doing, understanding the industry, understanding how consent and compliance and just different things work. And then you also asked, just looking at my notes, about the case law. Case law sometimes moves slower, although right now we may not feel that way with Hunstein. And it can develop in a more decentralized way. So it makes it difficult, save for a big impactful case out of a circuit court or Supreme Court, to move things sometimes as fast as CFPB's been able to do. And it can result in what we've seen, where in 50 different states, you may have 50 different things you have to do, right? And there's constant pressure from clients to say, well, how can I make this more efficient? How can I streamline it? Can I group states together? And then bam, we get a decision like the Hunstein that makes us all kind of stand up. So I feel that the case law has been pushing us here as well, just not in a way that maybe save for a decision every now and then that feels kind of quickish, in a way that's as quick to see. But going to Hunstein, just thinking about that, one of the reasons we're bringing up Hunstein here is because by shifting from this old paradigm into this new paradigm where our creditor clients are more like partners in the process and can do that without exposing themselves to increased litigation because they're not subject to the FDCPA, and working with us and knowing more about what we do doesn't do that. And the CFPB wants them to do that. It's their failure to do that that can cause them to have more risk. It's setting up an opportunity that if you've been able to work together in tandem effectively, perhaps you have an ability to argue that 1692C doesn't apply. Now, I want to be clear. I'm not saying this is a winning argument. I have no idea. It hasn't been tested. But guess what? I bet it's going to start being made in some of these copycat cases we're seeing being filed around the country, right, when one of the things you could see is creditors directing the information to the vendors on behalf of their debt collection partners and trying to take the position that creditors, that's not a violation of 1692C because creditors aren't subject to it. They're defined as outside scope. There could be some state laws we have to think about. I mean, this is why I'm not advising this is where we all just flock. but it is also something to think about from a defense perspective that could stand to help in cutting the legs out of Hunstein cases, but it requires this shift into the new paradigm and buy-in from both sides.
That's a great take on 1692, and actually a good lead into kind of the discussion of like the new paradigm. And I'd like to start with you, Heidi, here, because number one, we're really interested. Obviously, this is about the creditor's perspective, but before we tell you what we think this new paradigm should be, because you led a very important transition at U.S. Bank. I would argue we were well ahead of our time, and obviously very helpful to us in this development. But can you describe that transition and what it was from the creditor's perspective that you saw or needed to see as you were kind of making your own transition, whether you call it this new paradigm or whatever it was, but kind of your perspective on where you were headed?
Yeah, I doubt the thought of the old and the new paradigm was really, swirling in my head. It was more U.S. Bank was re-entering the litigation, and we were standing up our process and using some of the aspects of the old paradigm and at least how people had been traditionally giving out work and communicating with firms. And it was a lot of manual in nature. It was several systems. So we have to have one that communicates data, one that communicates documents, and then this goes to each of our firms. Then we have our own internal operational system, which, like many banks, isn't set up for litigation. So then you have all of this other work and FTEs you have to support to provide the oversight that Stephanie was talking about. And I was looking at that and having come out of a third-party law firm atmosphere thinking, like, I can't believe there isn't a solution or something better out there. This can't be the way it works for creditors, because with these new requirements that we have and these consent orders coming down, we have to have a new way to work. So I think my vision, which was, thank you, because you guys helped me bring it to life and then really create a lot of parameters around it. But my vision was to have a more modern creditor engaged relationship with our outside attorneys, with the vendors that they're using, with that process, to ease communication back and forth between the two of us, to have it centralized so that the data isn't getting sent to lots of different places, that we have kind of a location. And in my head, I was hoping for this one platform concept. I hadn't found that in the market. I wanted it to be flexible. A lot of the software I've worked in the past is fairly rigid. And so I wanted something that would allow us and potentially, hopefully other creditors would use this, we all have different risk appetites.
Right.
And the trends change. I don't have, I can't see into the future. I wouldn't anticipate the Hunstein case coming down. So how can we modify what we're doing to mitigate that risk or to see a trend? So I wanted something that had the flexibility enough and the partnership. We were talking about that with both the vendor and literally the software vendor, as well as our outside firms, to be working collaboratively to really create something that's a better customer experience, but also efficient. I mean, the idea isn't that you are just, creating more work for everybody, but the idea that it would result in something that's a win across the board. I mean, that was kind of the vision. It was a little pie in the sky. It's a lot of work. You guys have helped us, expand our litigation strategy to include a model like this. And I think this hands-on approach versus, I think, what was previously more set up to be hands-off. So getting hands-on is really difficult. But it's not just hands-on. I feel like it's hands-in, and we are in this together, trying to solve all of this as true partners in the strategy.
Right. That's great.
That's how I saw it.
No, I think it's a great analysis. I think that, so Tom, I'm gonna come to you now and say, so we have from Heidi kind of this kind of vision of the problem statement of what she was seeing. And so how do you actually describe, Tom, this new paradigm? Like, we're throwing around terms like creditor driven and consumer centric, but what does that mean? Like, how do we actually define that?
Well, departing from the place, as Heidi said, where it was sort of outsource driven, vendor driven paradigm into a new one where basically the creditors are driving the process. And if you're a creditor, you're probably looking at that. I know, Heidi was definitely probably out ahead of the curve on some of the perspectives that she had for this, for whatever reason. That can probably seem like a lot to take on. But I think if you break it down, there's a lot of alignment there with what a creditor really probably wants to accomplish in their collection strategy. Things like keeping their customers closer to them, being more in alignment with the sort of soft or hard hand of the regulatory, framework that they're working in, and their regulators. And then like shifting those ideas into, a strategy where they can actually accomplish them and do it with, scalability and control and transparency. So kind of getting a little bit more specific, I think the new paradigm is really one where the collection process is managed inside of an environment that is sort of created and controlled by a creditor, where data, documents, all the compliance requirements and the business processes and rules that creditor wants to implement are centralized in one place and not fragmented or decentralized across all the vendors and their vendors. And so I think the first sort of tenet in the new paradigm is that, the creditor sets the table for their process. A lot of that is going to be driven by outside forces, things like, the FDCPA or TCPA or state level laws. But a lot of it can then kind of dive in one more layer and get really specific with respect to how a creditor wants to manage their own strategy. Maybe that's because of the products they have, or their own, philosophy on collections, or, risk appetite, or whatever it is. But pulling all of that, first the data, and then on top of the data, the documents, compliance requirements, business processes into one place, means that the creditor has more control over them, more transparent, and it's just a lot more scalable. I think the other, idea of this is for creditors to invite the servicers that they work with into their environment. Now that can be inviting them literally into a UI, which, I do know US Bank does some of that, but not exclusively. It can also be inviting their servicers into that environment through integrations, using like modern integrations to really, add capacity to the creditor's strategy. And at that point, the creditor can kind of, stay in control of who they're working with and how that data is flowing throughout the process. So that's really the tenets of it: centralized data and business processes, and letting the creditor really kind of sit in the driver's seat for their collection strategy.
Great. Thanks a lot, Tom. And Stephanie, there's another angle here as well, which we mentioned at the outset of this, which is, we're talking creditor driven. And Tom just kind of laid that out and kind of setting the table for the servicers and vendors that they want to be able to oversee in that process. But the second part of that is consumer centric. And so, with the advent of things like Reg F and so on, how do you think this plays out in the new paradigm? We obviously had a lot of time to prep for Reg F, but how do you think that's going to play out against that?
I think it'll play out well. And just backing up for a minute, I hear sometimes a lot of skepticism on the third party side of things about whether creditors will be willing to engage in this way and provide this kind of support and be partners in this way. And I'm not here to tell you that they're all going to do it. I think it's going to be a unique relationship circumstance. I shouldn't say unique, but I mean particular is a better word, to the individual relationship with each creditor. And each creditor kind of has to choose their own adventure. And I think that this adventure makes a lot of sense for some of them, but they may not. But I know, for a lot of our large lending and bank clients, something like this seems to repetitively, whether it's the Oliver product or others that are out there, I'm not going to promote them or mention them at all. I'm just saying these types of things have appeal, because they're helpful on the creditor side in knowing what's going on and dealing with all the vendor oversight and other things I talked about earlier. But the other thing here, to your point, that we need to think about is that whether we want to do it or not, whether the law would mandate it or not, this CFPB is certainly, and it's not just a CFPB. I mean, this was also the case. The rule came out under the Kraninger CFPB, and the rule started under the Cordray CFPB. So essentially, a decade of CFPB has been pushing in the direction of consumer-centric decision making. Their name is the Consumer Protection Bureau. They have kindly, but in a facetious, we're not the Industry Protection Bureau, and they're not going anywhere. The chance to have them declared unconstitutional and dismantled is gone, right? That case is done. We've had another. It's certainly not going to happen from the Democrats, and it didn't happen when the Republicans were leading the way. So that's a lot of words to say they're here to stay, and their name's not changing. It did for a minute, still had consumer protection in it. It's changed back. So we have got to, as an industry, as a third-party collection and debt buying industry, we have to start embracing that this isn't going away. And it does mean, as I think Tom said earlier, and Heidi, it's a different approach. And if we're going to have to embrace it, making it easier to embrace it in a way that also helps our creditor clients makes a lot of sense to me. So in this type of environment, consumers can be empowered to establish their preferences. That's one of the things I've said for months when I'm speaking. I was just speaking about it earlier today to a client. When I'm speaking about what are the underlying kind of thrusts and principles of the CFPB's rulemaking with Reg F. One is putting consumers in the driver's seat, whether we like it or not, on how, when, and through what channels we contact them, including shutting us down completely, right? So that's something that's not going away anytime soon, in my estimation. Their experience is being able to be considered and captured throughout the process. Believe it or not, once we adjust to the fact that they're in charge, and whether we feel that that's fair or not, because they haven't paid their debts that they said they'd be responsible for, I understand that. However, there can be reasons for that. We see people all the time doing, things that I would say are irrational. Like I was talking to a client earlier today. Why would they ever pay if you tell them it's time barred? Why? They do. This is why really old debts get paid, and why, when they consume it, they do. I don't know where it comes from, personal obligation, a feeling of responsibility. I truly believe that at the end of the day, most consumers are not professional plaintiffs that are looking for ways to sidestep their obligations. Instead, they've gotten overextended. Life hasn't gone the way they want. Something unexpected has happened, and they don't feel good about not paying for something they got. That's why they're trying to not hear about it. So the more that we can react to that, drive the communications through channels that work for them and make them feel engaged in the process. Man, I know of companies that think that's where the next big boom is, and that's the best way to have effective recoveries going forward. So this helps to promote that. I've talked a lot with clients about having to manage contacts across channels, right? Under Reg F, for sure, call restrictions, at least today, only apply to calls, but there are other things you have to consider: time, place, inconvenient designations, things like that. Apologies, I have somebody who just got home from school. Give me 1 second. And I have 2 of them coming in. They don't always come in, but when they do, it's always at great times. So coming back to an omni-channel approach, this is helping to capture that in a way that might make it easier to keep track of, to do your 7 and 7 calculations, to know this consumer doesn't want to be contacted on Sundays at all, or Saturdays or Wednesdays or whatever, across all channels. It can help with managing that overall FDCPA prohibition that we've had for many, many, many decades about just no harassing or unfair communication strategies in the first place. And it gives you an opportunity, I think, to really liaise with your clients, your creditors, and you're working to resolve debts, set up payment plans, go outside guidelines. Maybe there can be more flexibility there and engagement with what the client would be okay with. These are all if I'm a collection agency, these are all really customer service oriented things that I think help with both types of customers. The consumer, because that's how the CFPB wants to see them referred to, as well as your clients that you have the agreements with to collect from these consumers.
Great, thanks, Stephanie. We'll let you.
Walker, can I add? I'd like to add just one thing to that. Just sort of tying it back to, data, and Stephanie's spot on with all the elements of how the consumer-centric approach is going to be part of the future. It's as a creditor, how do you implement that? And I think it comes back to centralizing the data. If you've got a consumer that's stated a preference to you through a particular vendor, you need to have a way to make that persist out to the future of that process. Whether it goes from agency 1 to agency 2 to agency 3, that data about that consumer's perspective or preference needs to stay in a place that's centralized, so that it transfers with the consumer without respect to who the vendor is that's working with them. And so really it just reiterates the need and actually magnifies the need for centralizing that, because now, you can only imagine the nightmare of trying to capture and disseminate these preferences that are going to vary by consumers pretty wildly without it. So these two things kind of tie together in a way, if you think about how to actually implement them.
Well, and Tom, I'm glad you said that, because I'd had another note to remind people that back when the ANPR came out, way back in 2013, there was a proposal in there about kind of a national debt registry to accomplish this sharing and consolidation and continuity of information across the lifetime of accounts. That did not get finalized. I mean, I think there could be so many difficulties, but within a single relationship, your point is well taken. And I wanted to, I had meant to remind you all of that before my minions came in. So thank you.
Thanks, Stephanie. Well, I'd like to jump now.
Walker, before you move on, one other thing on this, you were talking, Stephanie, a lot about a lot of your clients or being concerned about creditors sort of willing to do this. And I think that's out there, but there's skepticism amongst the third parties too. It's a new concept. They've invested in the old so far. They've have a lot built around that. So to sort of switch your system, but I think for those that learn more about this type of model and its benefits and its actual ease of use, but there's skepticism across the board about change, whatever change is. So, for us, we are really looking for firms who want to be firms of the future and to innovate and are willing to, I don't want to say take chances, but to try something new that aren't really stuck in, the prior era. So I'm not asking them to give it all up. But we as an industry need to step forward. We've been on our heels for so long, and it's kind of time that we stand up and try to stand up together with some processes that do all of the things that our agencies want us to do.
Actually, to echo you, Heidi, that was more the skepticism I meant, not on the creditor side, although the creditors could be.
There is some.
Yeah, I'm sure. But the thing is, I find third parties sometimes they just won't even ask. Right. And that's what I'm encouraging. I think exactly like you are, that there are opportunities in presenting yourself, if you're a third party agency or debt buyer, is a little bit more progressive on some of these issues that may not, sometimes they're going to be met with no, right? Like that is definitely going to happen. But sometimes it might not be. So I completely agree with you.
Right. So actually, it's a good departure point, because I'd like to talk now about kind of some of the benefits that you'll see out of this, because this is, I think at any time we're talking about paradigms and talking about changing from an old to a new paradigm, people change for only one of two reasons, right? Fear and opportunity, right? You change for fear because if you don't stop smoking, something terrible is going to happen, or you change for opportunity. Like if I make this change, I can achieve, some great outcome. And I think this is one of these changes where there's both risk or fear, if you will, and opportunity on the other side. And whether it's US Bank, obviously a customer of ours, or whether, Wells Fargo, another one of customer of ours, they're making these changes for a reason to achieve these benefits. So Heidi, I'd like to start with you there. Since we're talking about the creditor perspective, what do you, as a creditor, see as the benefit for this new paradigm of kind of creditor-driven, consumer-centric approach?
Stephanie, you used the word like confidence up front, and I can't even remember, but I remember that to me is this is an approach and a model that I have confidence in as a go forward model. It aligns to me regulatory expectations. It cares for our customers. So we as a bank still consider a lot of, this is a customer of ours, not sort of just a consumer. I think it gives the consumers choice across on how do they want to engage with us, and a lot of flexibility in that, in different ways to do it because of sort of the modern build of this. And side by side with that is it lets us be sure that our approach is integrated into the strategy. And so that the things that the bank values and that it aligns with our bank values, which is good for our brand, even in debt collection, there's a certain way, an approach that we would like to take it. From a functional perspective, I think it's when everything's all, centralized, and for us, it's very easy to audit. It standardizes our performance. It's really looking at the ability to, expand. So economies of scale, like that, those types of things. It works for that in this sort of model where all of our vendors are engaged with the bank. But ultimately, I think it goes back for me to that confidence in what's happening. We as a creditor can actually see what our vendors are doing. We have it right there. We don't need to go into their offices to be sure they're doing what they say they're doing. So for me, that gives us a very stable experience. So stability in a variety of ways that I think is important. I think it gives us agility for the changing times and expectations that come down the road. So it allows us as a creditor to sort of balance those customer needs with our needs to provide oversight and control in the strategy that we're embarking on.
Great, thank you. And Stephanie, coming again from a benefit perspective, I'd like to get your perspective on the consumer, right? The consumer, how does the consumer benefit from this new paradigm, or will they, right? I'd be interested in your perspective on that.
Well, I think the consumer benefits, but the way I say that is when you step back and look at it from the lens of what the CFPB might like to see, right? Or a more plaintiff-oriented judge or court. Because I don't know that people in the third parties, this is a real shift, right? I mean, unfortunately, collections has largely been marked by having to, sort of a difficult relationship sometimes, right, in being able to get consumers to engage. So even enhanced deference and respect to consumer preferences, while it's something regulators want, it's a real change, and there's fear around that, and it's real fear about will consumers engage, and I don't want to seem insensitive to that. Right. However, I don't think this ship is going to turn around. So we have to start embracing it and figuring out ways to make it work for us, to keep our profits up and the doors open. And it's the step forward that we're taking, whether we want to or not. But there are a lot of companies, I think, that really do want to, and they're embracing it. It is the future, and they're investing in ways to make it work. And that is because the consumer will have more control, and then that control can be shared across the nature of the relationship. There could be difficulties. I mean, I get it. If the consumer shuts it all down, they shut it all down. But they're not all going to do that. Right. Because we've thought in the past that, if we put time-barred debt disclosures, or if we do this, it'll shut it all down. It doesn't. It hasn't. It doesn't mean there isn't litigation. It doesn't mean there aren't challenges. That's for sure the case. But collections have continued, right? The industry has survived. We just came off a year of Surprisingly, for speaking generally, I know there are pockets that have been impacted differently, but in general, consumers in the pandemic were paying off certain debts at very high rates. So it's a good way to keep engagement with your consumer clients, if you will, your consumer customers, I think is the better word, and having them stay happy customers, which drives down litigation, regulatory complaints, Better Business Bureau, griping, going into a plaintiff's lawyer's office, figuring out how to state a claim, etc. It also allows for consistency and clarity between creditors, the collection agency service providers, how they want you to handle their accounts, how they want you to comply with those SOWs and your MSAs, how they want you to report information back to them. This makes that really easy, right? Maybe you don't have to send a spreadsheet every month. Maybe this can be real time. Maybe you can put it back on the client to go ahead and extract whatever they need. And it actually reduces your kind of oversight responsibilities as the debt collection agency to keep your client in the loop. They can go in anytime and see what's happening.
Right, great. And Tom, let you clean up here from the kind of the technology perspective on the benefit front here. Obviously, if this paradigm shift occurs, there are going to be a lot of people impacted by it, and a lot of those impacted are going to be servicers, and by servicers I mean there are going to be law firms, they're going to be data providers, and so on and so forth. I mean, from your perspective, and Tom, you also run law firms and done collection law firms before. Is this good? Is it good for servicers and law firms? Is it bad for servicers and law firms? Are there benefits that accrue to others other than the consumer and the creditor in this new paradigm?
I think absolutely there are. I'll try to outline a few of them. First, to pick up on a point that Stephanie made, this ship isn't turning around. And so as a servicer in this industry, there's constantly a target on your back, right? And the size of that target maybe varies over time, but it hasn't gone away, and I don't know that it is going away. So I think one of the benefits to this approach is really moving in a direction where we can shrink the target down, right? And there's a couple ways of doing that. The first one I think is more philosophical in nature. It's by being more in alignment with the creditors, and the creditors having a consumer-focused approach. I think that shrinks the target a little bit. It's a benefit to the servicers when you're in great alignment with your client, and they're in alignment with the people who are suing you potentially. So I think it's just a better position to be in. I think that the new paradigm that we're describing here, where the creditor is really controlling a centralized data environment, really sets the stage for a lot of additional benefits, primarily in just risk reduction, right? When the data is standardized and clean, when it's easily shared across servicers, you're picking up a file that somebody had before you, and you can rely on that data because it's clean and it's complete. That really helps. We're as servicers, you are dependent on the data that you're getting, incredibly dependent on it, and you're at risk when that data is not accurate or incomplete. And to the extent that we can get closer and closer to something that's real time, where payments that come in wherever they come in, or information that comes in wherever it comes in, is being shared and actionable in a place so that you as the servicer can make decisions and take actions with the most up-to-date information possible, is also going to just shrink that risk down. I think there can be some other benefits beyond just shrinking the target on your back, and that can come from operational improvements. So moving to a more modern technology environment, perhaps that is in this creditor-driven approach, you can really lower IT costs. You know, I know a lot of firms and agencies spend a lot of money on, you know, building their own data centers basically, and having server rooms and all of the infrastructure and weight that goes along with that. I think there's a lot of opportunity to shed some overhead that isn't really adding to the functionality of the service that's being provided. It's not improving a whole lot of outcomes. It's just, you know, it's just facilitating the existence of, you know, the status quo. And I think there's an opportunity to change some of that and reduce some IT costs. I think there's opportunity for automation in really making a lot of strides there and what can be automated. Again, that's really dependent on data, as well as the infrastructure, the technology stack, essentially, that you're able to work in. And, you know, automating more things reduces operational costs even further. And I would say the last bit is kind of tying back to the creditor relationships. You know, the more transparent your work is to the creditor, the less audit and oversight burdens there are. And the creditor can see a lot more clearly into what's happening, and that should lower some of the audit burden that they put on you, and therefore your cost to get through those audits. So I'd say those are the benefits to the servicers, at least as I can perceive them right now.
Right. Great. Well, thank you, Tom. And we're nearing the end of our time here. And before I just open it up to questions that we mentioned, we have questions in the panel. If you'd like to put anything in there, I just want to make everyone aware that again, this is kind of part one of a three-part series that we've been putting together around, you know, this new paradigm of creditor-driven consumer-centric collections. Talking about the creditor's perspective here today, and in about another 2 or 3 weeks, we're going to talk about the regulator's perspective, and then ultimately the servicer's perspective, and in the third event here. So, I want to, you know, before I go to questions, I just want to thank, you know, Stephanie, Heidi for joining us today, Tom as well for all of your insight around this. We don't have any questions that I don't think that were not answered on the over the course of the webinar here, based on the list that we've got. So I think with that, I will call a close to today's webinar, and again encourage everybody to join us on the next one, the regulator's perspective. And if you have questions in the interim, please feel free to visit us at olivertechnology.com/webinars, and you can call us and you can shoot us an email as well if you'd like to get in contact. So again, Stephanie, Heidi, Tom, thank you for joining us today, and we'll sign off for the time being. Take care, everybody.
Thanks so much.